Good morning, good afternoon, or good evening, and welcome to the BLM podcast. I'm your host, Caroline Kane, a partner in our property team, and today we're going to be talking about what happens when an 1886 act meets a very 21st century riot. So today we're going to be talking about the recent Supreme Court decision in the case of Mitsui Sumitomo Insurance versus the Mayor's Office for Policing and Crime, the impact that that's had on the industry as it is at present, the Riot Compensation Act 2016, and the impact that that's going to have when that comes into force around about September. On the 8th of August 2011, a gang of youths gathered in a car park in Enfield. That evening, the whole country seemed to have been plunged into madness, with pockets of rioting breaking out all over London and copycat violence all over the rest of the country. Birmingham city centre was heavily affected by the violence, and we all remember seeing the emails suggesting that we go straight home after work, the destruction that was very evident the next morning, and more than a few of our staff remember trying to leave one evening and opening the doors only to see a solid wall of police in riot gear. But back to Enfield. The gang marched across the fields and broke into the Sony distribution warehouse. They looted what they could carry, tossed homemade firebombs at the rest, and scarpered, scattering games consoles in their wake and leaving the one lone security guard in charge of the warehouse that night hiding in the shrubbery. And I don't blame him. The warehouse was rapidly engulfed in flames and was completely gutted in what is considered to have been the biggest arson attack ever in Europe. Over the nights of rioting, the damage sustained caused the insurance industry to take an unexpected hit of around 200 million. It involved 15,000 people, there were 5,000 crimes, 1,860 attacks of arson and damage, and 1,649 burglaries. And just like the rest of the industry, once the insurers had made payouts to the owner of the building and to Sony, who were the majority occupier, they looked around for someone with whom to share their pain. And it's at this point that the square peg of a very 21st century riot starts to get hammered into the round hole of the governing act, which dates from 1886. That may seem terribly old now, but I promise you that by the time we get to the bottom of this topic and back up again, it'll really seem comparatively recent. The Riot Damages Act 1886 provides that where there's been property damage following a riot, which it defines as persons riotously and tumultuously assembled together, the owner of the damaged property, or their insurers, may submit a claim for compensation to the local police authority. The police authority's liability is strict, with no requirement to show either fault or that it could have been prevented by a hypothetical, ideal and unlimited police force. So after the riots, claims were presented to the Mayor's Office for Policing and Crime by the insurers for Sony and the owner, as well as 3 uninsured businesses who had items stored in the warehouse at the time of the fire. Losses totalled 60 million once consequential losses such as loss of rent, trading losses had been taken into account. And 2 things happened. Firstly, the Mayor's Office decided that they really didn't want to pay out 60 million and the rest to the insurance industry. And secondly, the coalition government decided it might just be a good idea to have a little tidy up and overhaul of a statutory regime that doesn't provide for compensation for damage caused to cars during riots. Because, well, if you Google an 1886 Mercedes-Benz, you'll discover that that's the first car that anyone ever submitted a patent for. People weren't exactly leaving them out and about in the street at the time. So, the Mayor's Office challenged the claim for payment under the Riot Damages Act 1886, and the government got drafting. The first resulted in the case of Mitsui Sumitomo versus the Mayor's Office for Policing and Crime, which was most recently determined by the Supreme Court on the 20th of April of this year, and the second is the new Riot Compensation Act 2016, which received royal assent on the 23rd of March of this year. We've already talked about the facts of the Mitsui case, and when it got as far as the Court of Appeal, there were 2 issues in play. Firstly, whether or not there'd been a riot, and secondly, and the more expensive question, if the damage did stem from a riot, did the Act provide for the recovery of consequential losses, as well as for pure damage to the physical property on site? The Court of Appeal attempted to bring some sort of clarity to the 1886 Act definition of a riot. It's not particularly clear, is it? Persons riotously and tumultuously assembled. I mean, I've been to work Christmas parties that could fall under that definition. So how do you distinguish a riot from, say, a noisy burglary or a bunch of lawyers with a bit too much Christmas spirit? And does the fact that the gang approached over the fields, which was the most direct route, mean that they were approaching by stealth because they didn't go round the long way? The Court of Appeal looked at the number of people involved, the violence of the attack, and the manner of their assembly and their approach to the warehouse, and determined that this was a riot. This analysis was not then challenged when the case later went to the Supreme Court, so this stands today as the most recent guidance as to the definition of a riot under the 1886 Act. The Court of Appeal then turned their attention to the issue of damages, and in particular, whether consequential losses could be recoverable. The court looked at the language used in the Act and the legal obligations conferred by that language, and concluded that Section 2, subsection 1 of the 1886 Act provided a right to compensation for all heads of loss for which you would receive compensation under the current English law were you to go after the trespasser personally, and therefore that must include compensation for consequential losses. Round one to the insurance industry. And facing a payout of 60 million on the Mitsui case alone, let alone the rest of the market who were watching the case with interest, unsurprisingly, the Mayor's office appealed. And so we come to the Supreme Court's decision of the 20th of April 2016. Lord Hodge, giving the lead and only judgment, reversed the Court of Appeal's findings. Whereas the Court of Appeal had looked at the wording and effect of the 1886 Act in the context of a modern interpretation of statutory wording, the Supreme Court ruled that an Act cannot be considered in isolation, and that therefore the answer to the conundrum before the court would lie in history, not merely in legal linguistics. Lord Hodge pointed out that the actual wording of the 1886 Act does not provide for a blanket compensation for damage caused by riot. As I've already mentioned, the Act doesn't cover any provision to provide compensation for damage to cars, although there is probably a good reason for that given they didn't really exist in 1886. But it also doesn't cover claims for personal injury, or medical expenses, or for property that was located in the street. Lord Hodge's point was that the Act has only ever provided a partial compensation for damage caused by riots, and therefore to assign to the Mayor's office, or any local police force, the entire liability that would attach to a rioter, assuming you can get your hands on them, is improperly representing the intention of the Act. So what is the intention of the 1886 Act? And it's here that we need to take a quick canter through a little English legal history, as signposted by Lord Hodge, starting with King Canute. Yes, that King Canute. Though for the sake of your next pub quiz, I should point out that the story about King Canute is widely misreported, and in the original he was well aware that he couldn't hold back the tide and was trying to show his courtiers that no one was bigger than God. But we digress. A statute attributed to King Canute makes reference to a provision for compensation by the local populace if they fail to make hue and cry, which is to be paid by the residents of the local area at the rate of the weir guild, which is a measure of compensation that dates from the reign of King Ethelbert of Kent, who reigned from 560 to 616. Did I mention that the 1886 Act was going to start to seem quite modern? Anyway, the idea behind hue and cry is that it's essentially there to prevent the local populace from sheltering a criminal. In the days of hue and cry, if anyone saw someone committing a crime, they were to raise hue and cry, literally shout out that the crime was being committed, at which point every able-bodied person in the vicinity had to chase after the criminal. If they failed to catch the criminal, then the 100 were liable. The 100 doesn't refer to a number of people per se, but the residents of a particular area. In the Midlands, at least, they were literally the area of 100 hides, which is about 12,000 acres, but that varies across the country. And it seems as though whoever was administrating the Midlands at the time may have been unique in being such a stickler for detail. The point is, though, that payment by the 100 was quite literally payment from the people living within that area. It's community responsibility in its earliest form. So back in the days of King Canute, the laws of hue and cry essentially forced the 100 to stand in for the criminal and to accept his or her liability. And this lasted as the common law all the way from King Canute right up to the point of the first Riot Act in 1714. 1714 was the first time that law specifically applicable to riots was codified. And if you've ever wondered about the origin of the phrase reading a Riot Act, this is where it comes from. So the Riot Act 1714 provided that in the case of a riot, a local official had to turn up, read a prescribed wording, the rioters had an hour to disperse, and if they didn't, they were guilty of a felony punishable by death, and they couldn't even pretend to be a priest to get out of it. They were clearly not big on rehabilitation and second chances in the 18th century. But leaving aside yet more pub quiz trivia, the point that Lord Hodge makes is to say that before the 1714 Riot Act, the law put the 100 in the place of the rioter, very much as the Court of Appeal were trying to do in the Mitsui case. But what Lord Hodge says is that if the 1714 Act had wanted to simply codify the existing law, that's what they would have done. But they didn't. Instead, the 1714 Act put in place a statutory obligation for the 100 to compensate the victims of riots that was much more constrained and allowed for compensation only for loss of or damage to buildings. The provisions were widened slightly by case law to sneak in the inclusion of household goods within the buildings damaged by the riot, And the Black Act of 1722 added compensation for cutting down trees and destroying agricultural vehicles and equipment. As the world changed with the Industrial Revolution, over the next 100 years we had a little flurry of additional acts, all of which slightly widened the scope of the 1714 Act. So the Malicious Injury Act 1769 included liability for damage to mining and mills. The Compensation for Injuries to Mills Act 1801 is fairly self-explanatory. The Malicious Damage Act 1812 added industrial buildings and equipment. The Malicious Damage Act 1816 added more mines and collieries. The Seditious Meetings Act 1817, the Riotous Assemblies Act 1882, and the Remedies Against the Hundred England Act 1827 all provided some form of minor expansion. But what they also all had in common was that they restricted liability to various sorts of property damage. So sitting in the Supreme Court in March, Lord Hodge asked, in the face of 172 years of statutory intention, is there anything in the new Act of 1886 that suggested an intention to expand the existing regime? And the answer was no. And so the Supreme Court found that the 1886 Act sets out a self-contained statutory regime to provide compensation for property damaged in a riot, and that this is not the same as the police authority being placed into the shoes of the offenders under a strict duty to bear all of their liabilities. The 1886 does make changes. For example, the local police authority is brought in place of the 100, but it does not make such changes as to give it the meaning ascribed by the Court of Appeal. There's no doubt that this finding will have been a disappointment to the claimants, especially those uninsured businesses for whom the loss of profit on the goods stored within the warehouse tipped their businesses into insolvency. And I don't doubt that the rest of the insurance industry were hoping that the Court of Appeal's decision would have been upheld. So what does this mean in practice? Well, Mitsui and the other claimants will still recover for the property damage, but the exclusion of consequential losses, such as the loss of rent suffered by the warehouse owner or the loss of profit sustained by the owners of all those electronic gadgets stored within it, will mean that the sum will fall well short of the $60 million overall expenditure by insurers. The Supreme Court's decision means that recovery by insurers for the costs of the compensation which they paid to their policyholders following the 2011 riots is now limited to the compensation paid for damage sustained to the property and the goods within it. Before concluding his judgment, Lord Hodge also went to pains to stress that there is absolutely no question that this decision was influenced in any way by public policy considerations. Submissions had been made that it would be in the public interest for the court to find as they did. The judgment does take a step nearer to the new Act, and it is probably true that the general public have a greater appetite to pay for riot damage via the impact which it will have on their insurance policy premiums than directly from the public purse via the local police force. But the idea that this could be a factor in the Supreme Court's decision is roundly rejected. If there were riots today, then a property owner or an insurer could make a claim from the local police authority for property damage during that riot, including the contents of any building, but not for consequential losses. But what of the future? The 2011 riots proved to be an impetus for parliamentary scrutiny of the 1886 Act, and the coalition government in March 2015 produced a draft bill which on 23rd of March this year received royal assent and became the Riot Compensation Act 2016. In that Act, which we expect to be brought to life by a commencement order in September, the definition of riot has been modernised, adopting the definition in the Public Order Act 1986 of 12 or more persons present together who use or threaten unlawful violence for a common purpose, and whose conduct, taken together, would cause a person of reasonable firmness to fear for their personal safety. And I'm sure you'll agree that that's a significant improvement and much less likely to be confused with a lawyer's Christmas party. The Act also widens the definition of property and now includes buildings under construction, property on land used for business purposes, and any motor vehicles not covered by their own insurance, all of which currently fall outside the 1886 Act. That's the good news. The bad news is that whilst insurers will still be able to claim for sums paid out under their policies, claims will be capped at $1 million, and the decision of the Supreme Court backed up by the definite exclusion of consequential losses from any claims. In some ways, the Supreme Court's decision has been a first step towards the new regime. Whilst recovery of consequential losses has been ruled out by that decision, there's still no limit to the sums recoverable, which opens up the various police forces to exposure to some sizable claims, even on property damage alone. But were the country to be plunged into another season of unrest after the new Act becomes operational in September, the situation for insurers would be very different. Had the London riots happened under the new regime, the ABI has estimated that 99% of commercial property claims for material damage to property would be fully covered under the £1 million cap, but that the combination of the cap and the restriction on consequential losses would have meant that only £1 of every £10 paid out by insurers is likely to have been recovered from the local police authorities. Insurers would have been left bearing the brunt of it. For property insurers, the scope for recovering outlay following a riot is narrowing, and as we move into policies written under the new regime, thought will have to be given as to how best to provide riot insurance where the recovery will be limited. I suspect that it's going to take a little while for the market to balance out the risks of rioting at the scale we saw in August 2011 versus the appetite and marketability of policies with an increased premium. And whilst we hope that it's insurance that no one ever needs to call on, it's going to be very interesting to watch developments over the next few months as the system beds in. This is, of course, only the tip of the iceberg where this subject is concerned, and if you've got any questions or there's something that you think we could help with, please do get in contact via our website at www.blmlaw.com.